When you apply for credit, if the credit guarantor or lender is going to deny your credit request, what they're required to do under the Fair Credit Reporting Act is send you what's called an adverse action notice. The adverse action notice is just a letter they send you and says, hey, you applied for credit on this date, and we are either going to outright reject your credit, or we're going to give you credit on terms that are a little higher than what you expected, so a higher interest rate than what you were looking for. And when they send you such a letter, what they need to do is the law requires that they tell you which credit bureau did they look at. Is it just one of the credit bureaus, or did they look at all three? And based upon what they looked at in pulling your credit, that's what caused them to give you a worse rate or outright reject you. So if you get such an adverse action notice, the letter telling you that you're denied or getting bad terms, go and look at that credit report and see what it was. Was it something, a mistake you made in the past and missed a payment? Or is it something that's outright fraud that you never asked to have on your credit? And if that's the case, that's when you need to contact Loker Law, go through the dispute process, and hold them accountable for letting the fraud happen. In order to dispute an unfair credit denial, once you get that notice that it occurred, which is called an adverse action notice under the Fair Credit Reporting Act, what you need to do is go through the written dispute process, which is better as opposed to the just calling and disputing. The reason a written dispute process is better is because it allows you to fully tell your story, not only through your words in a letter, but also by providing documents to substantiate your claim. That could be a police report, or, for example, if an account was opened when you were traveling, you could give them a plane ticket showing you weren't even in the area when the account was opened, or you weren't even in the area when your debit card was swiped. And you send all of that into the bank or the credit bureaus. And if at that point they reject your dispute, that's when you have standing to bring the lawsuit against those defendants for not protecting you as a victim of identity theft. If you were denied credit and it's based upon issues that might have happened in your past, so you missed a payment, or you forgot to send in a check to your financial obligation on time, what I'd recommend doing is get a credit card that you only use for gas, or you only use it for groceries and nothing else. Then every single month when your payment is due, pay that credit card off in full. When you have that history of making on-time payments every single month, every single time for an extended period, that's going to bring up your credit. And those issues that happened to you in the past, those become less and less relevant to the credit score models. And what you want to show them is that was a mistake in the past, but here's who I am now. I'm the kind of person who pays on time. If you have fraud in your credit, and that's what's bringing you down in terms of your credit score, the best, most efficient, and most economical way to deal with that is to get Loker Law on the case, because what we can do is bring a case on a contingency basis, meaning you never get a bill from us, whether it's for our costs or our fees, and we can file a lawsuit. And the goal of the lawsuit is to not only to get that fraud to go away, get it off your credit, have the debt collector stop calling you, but we can also get you damages. We can get you money from the entity that rejected your dispute, and it could be a substantial amount of money. 5 figures, 6 figures, 7 figures, depending upon the scenario, all because these banks didn't listen to you and ignored your rights as a consumer. On average, these cases, when we're pursuing banks or debt collectors or credit bureaus, on average, these cases take about 200 days. That's 6.5 months, 7 months on average. So what that means for you is that sometimes consumers think when they're reaching out to an attorney, this litigation process is going to go on for years. That's not what happens in this area of the law. These cases, when they get filed, would typically get resolved within 6 or 7 months. So if you receive a notice of a credit denial, you need to begin that process as quickly as possible. The process being the dispute process and contacting Loker Law, so that you can move on from this and have a clean slate in your credit report, get rid of these fraudulent accounts from the collectors and everyone coming after you. And you can do so in a relatively quick manner. Yeah, if your credit application has been denied or you've been rejected in terms of applying for an apartment or what have you, don't let it get to you. Don't overreact and just bury your head in the sand. If you become proactive in any disputes and you contact our office, we can help you take care of this within 6 or 7 months. And at that point, you'll have a clean credit report, you have some money in your pocket, and it didn't cost you anything since we operate on a contingency basis.